Hello everyone, I am Rushikesh Verlekar. I am going to discuss on the topic History of Business Law. History of Business Law. Business law encompasses all the laws that dictate how to form and run business. This includes all of the laws that govern how to start, buy, manage and close or sell any type of business. History of law. Legal history or the history of a law is the study of how law has evolved and why it changed. Legal history is closely connected to development of a civilization and is set in the wider context of social history. Business law in the world. Many countries have adopted civil codes which contain comprehensive statements of their commercial law. A civil code is a systematic compilation of a law designed to comprehensively deal with the core areas of a private law. A jurisdiction that has a civil code generally also has a code of civil procedure. In some jurisdictions with a civil code, a number of core areas of a private law that would otherwise typically be codified in a civil code may instead be codified in a commercial code. History of a law in India. India has a recorded legal history starting from the Vedic ages. It believed that ancient India had some sort of a legal system in place even during the Bronze Age and the Indus Valley civilization. Law as a matter of religious prescriptions and philosophical discourse has an illustrious history in India. Emanating from the Vedas, the Upanishads and other religious texts, it was a fertile field enriched by practitioners from different Hindu philosophical schools and later by Jain and Buddhist. Secular law in India varied widely from region to region and from rural to rural. Court systems for civil and criminal matters were essential features of many ruling dynasties of ancient India. Excellent secular court system existed under the Mauryas 321 to 185 BCE and the Mughals 16th to 19th century, with latter giving way the current common law system. Law in British ruled India. The common law system, a system of a law based on recorded judicial precedents, came to India with the British East India Company. The company was granted charter by King George in 1726 to establish Mayor's Court in Madras, Bombay and Calcutta. Judicial functions of the company expanded substantially after its victory in Battle of Plassey, and by 1772 company's court expanded out from the three major cities. In process, the company slowly replaced the existing Mughal legal system in those parts. Law after independence. At the dawn of independence, the Parliament of Independent India was forged, where a document that will guide the young nation was being crafted. It will fall on the keen legal mind of B.R. Ambedkar to formulate a constitution for newly independent nation. The Constitution of India is guiding light in all matters executive, legislative and judicial in the country. It is extensive and aims to be sensitive. The Constitution turned the direction of a system originally introduced for perception of colonial and imperial interest in India, firmly the direction of a social welfare. The Constitution explicitly and through judicial interpretations seeks to empower the weakest member of the society. India has an organic law as consequence of a common law system through judicial pronouncements and legislative action. This has been fine-tuned for India conditions from an artifice of a colonial masters. The Indian legal system has evolved as an essential ingredient of the world's largest democracy and crucial front in the battle to secure constitutional rights for every citizen. Thank you.